Your Lordship. Your Lordship,
Yeah.
if I may, Your Lordship. Your Lordship,
Yes.
I beg to mention, Your Lordship, item number 5, Your Lordship. Though this has been listed in the top of the list, Your Lordship, I have some difficulties, Your Lordship.
When will you have it?
After 2 weeks, Your Lordship. Then after a week, Your Lordship.
18 matters.
I understand, Your Lordship. But
We'll have it next week. You give me a date.
next week, Your Lordship, I will be outside, Your Lordship, which is why, Your Lordship.
When are you going? Any day, whenever next week. Till Friday, I'm here.
Then,
You're convenient. I'm ready.
You have 40 respondents.
yes, Your Lordship.
My brother.
You will also not be here
Uh,
next week.
next week I'm here.
Here. We'll try on Tuesday. Make a try. Tuesday.
Oblige, Your Lordship.
We'll have prayer.
Interim may be
prayer of the
continued.
parties.
Until further.
Tuesday. Tuesday, Golade. Tuesday.
And Your Lordship, item number 26 as well, Your Lordship. Your Lordship, as per instruction, we have to take some instruction from the department.
I think I handled this did this matter last time.
Your Lordship, I have
Okay,
no
fine.
idea, Your Lordship.
What is it?
26.
The laser Ajarika, yes.
Some pension matter.
Your Lordship, the brief is with Mr. Thalpin, Your
We'll
Lordship.
have it next week. Thursday.
Oblige, Your Lordship.
May I please, Your Lordship? I would like attendance on 11, bail application. The leading counsel, some illness and sickness, is unable to appear, and the matter may be adjourned, and may list
You're for the petitioner.
on the behalf of the petitioner counsel, Gautam Phukan,
The
sir.
prayer made on behalf of Mr. Gautam Phukan, Ranak Council, appearing for the petitioner, lists this matter again after 2 weeks on a date to be fixed by the registry.
5th of June, Your Honor, if possible.
No date. You make a mention. We'll have just.
Okay, ma'am.
Lordship, in this matter, also charge sheet already been submitted, Lordship.
Pension
Yes.
Council is having some.
Lordship.
Much obliged.
My lord, may I mention item number 23, export order. I'm on behalf of N Rama. Today not able to filing reply. Give more sometimes, my lord.
For filing reply
Yes, sir.
on the prayer made on behalf of Mr. N. Rama. Lists this matter after 2 weeks on a date to be fixed by the registry. In the meantime, the respondents are at liberty to bring on record their respective pleadings.
My lord, I'm for the petitioner in this case. There is interim.
The interim order passed earlier to continue until further orders.
I'm for the state, Lordship, here. I'm for the state.
Write the names. Ms. L. Hage, an additional PP appears for the state respondents.
My lord, I beg to mention item number 23.
20?
23.
23.
22. 22.
22.
Yes, I'm for the respondent number 2 and 3. I need some time for filing reply.
वही same order. उनका नाम ले लो. बाकी सबका presence. You are for the petitioner.
I am for the respondent, Your Lordship.
You
Here
are
in
appearing as the PP here.
yes, Your Lordship.
Mr.
Your Lordship, here in this case, we have received the case diary, Your Lordship. So in that case, Your Lordship, case diary may be returned, Your Lordship.
The case diary received shall again be produced, shall be written and be produced on the next date of
Yes,
this.
deeply obliged, Your Lordship.
एक date दे दीजिए इसमें for 2 weeks.
Your Lordship, 26 July may be fixed, Your Honor, Your Lordship.
So we'll give a date. Why so long? Small matter, you can finish it off. 4th of June, no problem.
4th June.
Okay. Yes, next, any more?
Lordship, I beg to mention item number 9 and 10. I'm for the petitioner in both the matters.
Your name?
S. Yirang.
Yes?
Yirang.
You're making a prayer on behalf of whom?
El Parme.
On a prayer made on behalf of Mr. L. Parme, 9 and 10, दोनों का separate order मानना. List those matters again after 2 weeks or date to be fixed by the district.
Lordship, in item number 9, there is interim order.
Interim order passed earlier to continue until the next date of this.
Highly obliged.
May I, my lord? I beg to mention item number 8. My lord, I'm not a petitioner here. My lord, this matter will fix after 2 weeks.
Temporary. 2 weeks,
Much obliged.
fixed by the registry.
Lordship, I beg to mention item number 18. Lordship, due to sudden health issue, conducting counsel 8 for petitioner 8 attack couldn't appear today. Kindly adjourn for 2 weeks.
It is submitted at the bar that Mr. A. Tatak is indisposed and accordingly not present in the court. Full stop. Accordingly, registry to this matter after 2 weeks or take 2 weeks by.
Obliged, Lordship.
May I, Lordship, I beg to mention item number 17. On the consent from the other side, Lordship, the matter may be listed after 3 weeks.
Same order, 2 weeks, huh?
Obliged.
Yes, Mr. Tiwari, what brings you here?
The case brings me here, you know.
Naturally, this court is not something to be looked up.
Lawyers come to the court only for a livelihood. And it's both ways, my lord.
Both ways. Which is your matter?
Item number 2, top of the list.
Okay, we are coming to them. Yes. Yes. What is the,
Yeah, my lord.
you are paying for the petitioner?
Yes, my lord.
Okay.
My lord, as per instruction by the petitioner, my lord, I may be allowed to withdraw this matter. Here is the, my lord,
Your thing goes.
my lord, here is
The
the,
endeavor, now your thing itself goes.
my lord, here is the authorization letter.
I don't maybe believe you. You are for the petitioner.
Yes,
What is your name?
Tamo Taggu, Uti Taggu.
Likhna to. Mr. T. Taku Learned Counsel for the petitioner submits on instructions that he may be, on instruction from the petitioner that he may be permitted to withdraw the present writ petition. Full stop. Prayer accepted. Writ petition stands dismissed for withdrawal, for non-prosecution. Stands dismissed on withdrawal. Full stop. Mr. H. Lambu, you are appearing for?
Union of India, M. Kato. On
M,
behalf of-
Mr. M. Kato,
on behalf of M.
on your name? M.
N-
Kato,
N. Sora.
M. Soran, Learned Counsel representing Mr. M. Kato is present on behalf of the Union of India Respondents and
13,
Mr.
14.
and Madam Gamamlide for us, yeah, for the all the state respondents. Appear, right, for the state respondents and Mr. N. Lambu, Learned Counsel, appearing for respondents number H. Lambu for respondent number 16 to 86. Anybody left out? No.
No. Much obliged.
यहाँ पर ना हो भाई you are responding.
Okay, so when we together. In item number 3 also you are appearing
Yes,
for petitioners.
yes. These are common cases. The item 3 was filed earlier, 2 later on. But issues are the same. And in fact, if you go by the contention of the item number 2, the petitioners made therein, if the relief is given to them, they would be after the petition in item number 2. The private respondents will go. Anyway, my lord, this is the case wherein the facts and the law evolved during the pendency of the petition. Evolution of both facts and
Mr.
law.
Punning has got no place to sit.
No, in fact, I'll make it clear. There is no need for him to sit also over here.
But the conceding.
So far as
What
Sir,
is,
please,
what
kindly,
what
why
is
to
the issue?
interrupt?
Mister, just give me a hang.
It is an inter-se seniority dispute between direct recruit and the promotees.
Hmm.
The promotees belong to three different classes.
Hmm.
Number one, promotee simpliciter. Number two, deputationist, absorbed, then promoted. Third is a very unique category, unique because of the nature of the administrative order they were beneficiaries of. It's a case of regularization, but again, they were also promoted. And all these three categories of the private
Regularized
respondents.
in the feeder cadre, then promoted.
Oh, yes. And all the three categories, in fact, these respondents, they superseded in seniority the present petitioners who are direct recruit.
Direct.
I am for direct recruit. So this is what the case is all about. Since, my lord, facts are complex,
Is it your
Plenty
case,
of-
Mr. Tiwari, that when you were inducted into service as a direct recruit, these petitioners, none of them were there were born in the cadre?
I'll put it this way. When the petitioners of item number 2 were directly recruited and joined the service as urban program officer, at that very point of time, neither of them were urban program officer on regular basis.
They were on ad hoc basis.
Some of them, my lord, that's fine. It's better to begin.
Just give me a hand.
Uh,
You know, understanding problem is there. So slowly I understand. So
Some of them were serving on officiating basis.
officiating.
Some of them were serving on deputation.
Okay.
Some of them, there were two categories at that very point of time, either officiating or on deputation.
Deputation. So this will come to the officiating category. So officiating after a regular DPC or just picked up?
Just officiating.
Just officiating, picked up. Now, when you say there is a direct recruitment and a promotion element, there is a demarcation of vacancies, 50-50, 20-50.
Quota rule violated.
Fine, but is there a demarcation of vacancies, 50%?
There is.
There is. Now, on the date, these people were officiating, given officiating promotion. Now, were there vacancies available for promotees in that cadre?
Milord, the thing is like this. Some of the cases, I am going to show there were no vacancies.
One.
They were adjusted against direct recruit quota.
So,
Some of them were indeed adjusted against the promotee quota, but in their case, what happened was they were in a feeder cadre.
Hmm.
They were in the feeder cadre, and from feeder cadre, without being regularized over there, also brought on officiating basis over here.
Fine.
So all kinds of cross
Fine.
facts.
we'll only consider the entry into that you
Entry in all the three cases, my lord will find is vitiated.
Now, what was the methodology utilized or done, followed for regularizing them?
All kind of devices which are available in service jurisprudence, sometimes out of service jurisprudence, were used to give them the benefit.
Where DPCs convened,
Not. All administrative orders and passed in a wonderful way.
so the rules, there is some rules governing this.
Oh, yes, 2006
So
rules.
the rules also contemplate a methodology for.
Oh, yes.
You mean to say that was not followed?
Yeah, but rules violated. That's why I'm going to show that.
Understanding.
Yes.
I'm learning.
You know, we all learn.
I'm
We
learning.
all learn. We all
Okay,
learn.
learned concept.
No, we all learn. We all learn on regular basis.
Now, Mr. Tiwari, one thing. They were brought on officiating basis, like they use the word from the road. I use that word without sitting in an AC room. They came in because AC is the interview or selection. Now, they came in, they continue on ad hoc officiating basis. You were recruited on direct recruitment basis through a process of selection, right? You had a process of selection.
Oh, yes, regular basis, regular selection.
Regular.
Advertisement.
Now,
Recruitment conducted.
if there was no regular DPC conducted for their induction in any manner
Oh, yes.
on regular basis, if you demonstrate that, is this court required to go into any other aspect?
There are two ways to cut the matter short and to ensure that the entire case is over in 15 minutes. I'll take them 10 minutes. I will show that. That's the way out. That's the way out, accept it. That's the way out. But
And
there
we,
is,
we require, we will put in a line that at best they can hold a regular DPC after demarcating the vacancies available And on the date the vacancies arose.
PCC was there.
That is, sir,
Correct.
please,
You
sir,
will
I'm
get
not
it,
eating.
Sarah, you will get it.
That's why, my lord, sometimes too shortcut an approach may create a problem.
I'm not
So
on that.
I'll have to at least explain things.
I'm not on that. I'm only on the legal part. Then we can put in a rider
Hmm.
that from the date the vacancies arose, the authorities at liberty to hold a review DPC and then consider and proceed.
Let us understand the facts first, my lord, little
Okay.
bit elaborately.
Take me to the first to the.
No, there's something.
You take your.
I'm making it a very, I'm giving a very brief note covering the entire.
It doesn't look to be a brief note.
It's a brief note because all the relevant enclosures
Oh,
are
you
put here from the writ petition. I have given the cross references.
Hmm.
So first of all, the petitioners, my lord,
Hmm.
total petitions are 1 to 5.
Hmm.
5 petitions are here. That is item number 2. Sankoli is one of them I'm not dealing with. Oh, Mr. Panging is here. My lord, so far as Mr. Panging is concerned in the other case, that is item number 3. Mr. Panging is the counsel of respondent, private respondent number 1 and 2.
4 and 5.
That is 4 and 5. Because private respondents begin from 4. So 4 and 5 he represents, and I am conceding that I cannot claim seniority over a private respondent 4 and 5. That is the client of Mr. Panging.
That may be record.
So his.
Reiterate that.
Because
Okay. What is it?
So, my lord, the petitioner 1 to 4 were directly recruited as urban program officers in the Department of Urban Development and Housing through the regular process of selection conducted by Arunachal Pradesh Public Service Commission and were appointed with effect from 21 to 2012. So they are from 2012 batch 1 to 4. Whereas petitioner 5 through the similar process was appointed with effect from 16/7/2014. The relevant details I have given in the chart. All of them are civil engineers, BE civil, with respective dates of appointment. Petitioner 5, it is July 2014. The rest 1 to 4, 2012 batch. By office memorandum dated 16, below, there are 2 dates because over here there is a very peculiar practice. They prepare a order on particular date, it will be signed 7 days later. So 2 different dates given. By office memorandum dated 16/23/12/2014, which is enclosure A, the cross reference I have given annexure 8, page 50-51 of the writ petition. Provisional seniority list of UPOs were circulated and claims and objections were invited within 30 days from issue of the memorandum. In this provisional seniority list, the names of the petitioners appeared at serial number 15 to 19 and the list and names of private respondents 3 to 14. 3 to 14 are the total private respondents, my lord, in the case of Sophia Ligo. Private respondents 3 to 14 who were then either officiating as UPO or were serving on deputation in the said capacity were placed above the petitioners. It was clarified that the inter se seniority of the petitioners and the respondents would be finalized after regularization of the officiating promotion and absorption of the respondents. So inter se seniority would be finalized then only once they are regularized, absorbed, etc. Lordship will just see the enclosure A, capital A, the office memorandum at internal page 6. Lordship will come to second chart.
Provisional interest seniority.
Yes,
Where are the petitioners here?
I'm showing it.
15
The
to-
place of the petitioners. The petitioners, my lord, will find the petitioner's name begins from that is serial number 15.
to 19.
15 to 19, yes.
And
15 to
the
19. And so
respondents-
far as private respondents are concerned, 3 to 14. 3 to
Serial
14,
number 3
3,
to 14.
3 to 14. And there may not from serial number 3 to serial number 10, all of them are officiating as UPO.
And the 11 to.
And
14.
11 to 14 on deputation, serving.
And tell me here, Mr. Punning's clients are?
My lord will see also here the dates in the chart itself. That is the lord,
Mr. Punning-
provisional seniority list.
Mr. Punning.
Mr. Panging client, my lord will find serial number 1 and 2 of the earlier chart, the top of that, the first chart.
Top portion.
Yes, top portion. P.K.
Tungan-
Tungan and Ria
Tungan and
Pova.
Pova.
Yes. Item number, the serial number 3, Sankoli Sonam is the petitioner in the other case. So he is no longer claiming seniority over Ria Povak and Tungan. Ria Povak and Thongan are represented by Mr. Penge. That is the other case. Now, my lord, one more thing I will clarify.
No, just a moment.
Ah.
They were appointed as UPO on 28/11/2007.
Yes.
Joined on 28/12/2007.
Yes.
Promoted. Date of initiation of DPC requisition absorption.
Hmm.
So they were absorbed here in this cadre from a date prior to their joining. Or
Yes.
is this the date of the DPC? 28/4/2007?
28/4/2007. Which chart my lord is referring to? Oh, that is of Ria Povak.
Hmm.
Ria Povak, date of initiation of DPC and requisition for absorption.
Hmm.
28/4/2007. That is, I think, DPC, my lord. I'll just, but I looked into calculations and other things, then I realized that I can't claim seniority over that. So that's why there was a change of thought. Once I unfold the whole case, it will be clear. But my lord, I'm sure Sankoli Sonam can't claim seniority over the other two. P.K. Thongan and Ria Povak. But yes,
Why is that?
my lord, I'll come to that. I'll come to that.
Hmm.
But my lord, let me complete the Sophia legal first.
Then you file the objection.
Yes. So my lordship has seen over here in the chart. So then I come to the paragraph 3. Being agreed by their placement below the private respondents who were not even serving as UPO in regular.
मुझे क्या upload कर लो? चाहिए तो बुला लेगा.
Being agreed by their placement below the private respondents who were not even serving as UPO in regular stroke substantive capacity, petitioners filed their claims and objections dated 3/1/2015, and enclosure B is there, which was responded to by office memorandum dated 24/2/2015, enclosure C, stating that the issues pertaining to the seniority shall be determined only on the regularization of the officiating services of other UPOs. So I had no choice but to wait. On 2/4/2015, the Deputy Secretary to the Government of Arunachal Pradesh, Department of Urban Development and Housing released the final interstate seniority list of the UPOs as on 24/2/2015, only in respect of those very officers in whose case there was no controversy pertaining to their seniority. The names of those officers can also be seen in the first chart of the office memorandum dated 16/12/2014. That is the one your lordship has already seen.
That means you mean to say Mr. Thungon till Papelenu Cree,
Yes,
they
yes,
were finalized.
yes, yes,
Others not finalized.
yes. All these UPOs were then the senior-most 8 UPOs who in any case were above all the petitioners and the private respondents 3 to 14 in terms of seniority. That is in the context of the seconded petition, Sophia Lego. Subsequently, and that's important, my lord, on 17/6/2015, enclosure D, the meeting of the DPC was held and it recommended the promotion of the private respondents 3 to 14 from the date of the DPC meeting, that is 17/6/2015.
Hmm.
Obviously, my lord will wonder, if that be the case, how come these private respondents became senior to the petitioners? Because it is as per the recommendation with effect from the date of the meeting of the DPC, 17/6/2015, giving elaborate reasons for its recommendations. DPC also clarified that the respondents 3 to 8 will be placed above the respondents 9 to 12, and for fixing interstate seniority of respondent 13 and 14, it suggested that their case be referred to ARN Law Department. So 13 and 14, ARN Law Department will decide, and in their case, what happened was absolutely wonderful. All canons of service jurisprudence were broken, they went above everyone else, 13 and 14. 3 to 8 will be above 9 to 12. That is how their interstate seniority will be fixed, and all said and done, all of them will be below us. So, my lord, had they been below us, there would have been no problem. Lordship will see the DPC. The DPC is enclosure D, annexure 11 of the writ petition. Internal page 12. Lordship will see from the second paragraph. Internal page 12. It is seen from the records that there are 3 categories of officers to be considered in departmental promotion committee. Promotion of AUPOs to UPOs as per inter-se seniority. AUPO Assistant Urban Program Officer. Absorption of 4 UPOs on deputation. Promotion of in-cadred AUPOs. So these 3 categories are there. Just a minute. There are 8 AUPOs recruited directly by the department who are serving as officiating UPO eligible for promotion to UPO as per their seniority and length of service. The promotion for the serial number 01206, 01206, that is R. Mihu to Tasar Taro. R. Mihu to Tasar Taro. The below is recommended with effect from the date of DPC meeting 17/6/2015.
What happened to this to 7 and 8?
The following, I'll come to that. I'll come to that.
Following 4 UPOs who are on deputation have
Just a
been
minute.
observed and written quota. So and so.
I'll come to that. The following 4 UPOs who are on deputation have been absorbed against direct recruitment quota. The date of TPC meeting 17/6/2015. So their absorption was against direct recruitment quota, the 4 UPOs. These 4 UPO are Tada, Tarang, Tai, Keli, Kak, Nabam and Nabam Kai. These 4. The following officers who were brought from PWD to this department as AUPOs on encadrement basis and subsequently absorbed on 26/8/2009 are also promoted with effect from the date of DPC meeting, that is 17/6/2015. So, my lord, as AUPO, they were absorbed on 26/8/2009, Lord, you will remember, are also promoted with effect from the date of DPC meeting, that is 17/6/2015. Then come 13 and 14. The DPC could not decide in their case, and the reasons were obvious once I come so far as their case is concerned.
6 promoters given in
6 promoters given in table 1 will be placed above the 4 absorptions given in table 2. So 1 will be above those who are in table, I'm sorry, there is
Table 1, 1 to 6.
1, 2, 3, yes. Table 1 will be placed above the 4 absorbees. Yes, table 2. So table 1 will be above table 2. So far as table 3 is concerned, DPC was indecisive. And the reasons were obvious. For the inter-se seniority of these 2 promoters given in the table 3, the member of DPC suggested to refer the case to AR and Law Department for waiting. There is a court case filed by such and such, such and such. So, my lord,
So
this
that is
the
why
recommendation.
Kalingdai and Giluk,
Yes.
table
yes.
1, they were not.
Yes. So, my lord, had the recommendation of the DPC been complied with,
Hmm.
there would have been no controversy, no dispute. Because so far as inter-se seniority of the private respondents are concerned, my lord, we are not worried so long as they are below us.
No, Mr. Tiwari, next clause 6 of your that written note.
Yes, I'm coming to clause 6.
So they were promoted.
Yes, that is
Is that
why,
right,
that
Prof?
is how difficulty.
17/6.
I'll come to that. So, in compliance of the recommendation of the DPC, the Commissioner Department of Urban Development Housing by an order issued under Memorandum 39/2015 enclosure E promoted the respondent 3 to 14 with effect from 17/6/2015. My lord, had there been a full stop over here, there would have been no case. The events start taking shape thereafter. Subsequently, by an order dated 17/12/2015, after 6 months, issued under memorandum dated 22/12/2015, which is impugned, the state respondents modified the order dated 39/2015. So the order of 39/2015, by which recommendation of the DPC has been implemented, the order is, my lord, modified. That's why I say, my lord, they have used devices unknown to service jurisprudence. The state respondents modified the order dated 39/2015 and regularized the promotion of respondent 13 and 14 to the post of UPO retrospectively with effect from 1/11/2008. Meaning thereby, my lord, they went above even Sankoli Sonam, the petitioner in item number 3, who is a recruit of 2009, not to speak of the data recruits of 2015, who are here in this case before your lordship. So they went above everyone, 13 and 14. Fixing their seniority in the said cadre notionally with effect from the said date, even though They had joined as UPO on officiating basis on 6/7/2012. Lord, they get seniority in the post of UPO with effect from 1/11/2008, whereas they started officiating as UPO only from 6/7/2012. And as on 1/11/2008, these respondents were serving as AUPO on deputation basis, and they were absorbed as AUPO only with effect from 26/8/2009. So, my lord, practically, entire, my lord, from the AUPO itself, my lord, they were given the promotion of UPO, regularizing everything.
So it would tantamount that they were absorbed not as APO, but
Yes.
as UPO.
Yes. Yeah, correct. Practically, that is the situation.
Got it.
It's all by administrative orders.
Now, Mr. Just to think.
Then next.
Then this.
Hereafter
orders
by
have-
another order, dated 18/1/2016, this is also impugned. Enclosure G, Annexure 12 of the writ petition. The state respondents, without holding review DPC, I'm making it clear here, emphasis mine, again partially modified the order dated 39/2015. Same order is being modified repeatedly. Again partially modified the order dated 39/2015 and promoted the respondent with effect from 27/8/2009. Respondent 4 and 5 with effect from 25/8/2009. Respondent 6 and 7 with effect from 6/7/2012. And respondent 8 with effect from 7/7/2012. Thus retrospectively regularizing the officiating promotion of respondents 3 to 8 as UPO, contrary to the recommendation of DPC dated 17/6/2015. Thereafter, the Department of Urban Development and Housing by Office Memorandum dated 23/3/2016 circulated a fresh provisional seniority list of UPO showing respondents 3 to 8 and respondent 13 and 14 senior to the petitioners. Being agreed by the provisional inter se seniority list, the petitioners submitted their joint claims and objections on 15/4/2016 and gave reasons for showing their names above the private respondent 3 to 8 and respondent 13 and 14. When the objections of the petitioners were pending disposal, the Commissioner, Department of Urban Development and Housing by order issued under memorandum dated 31/5/2016. This is also impugned. Further modified. So this is the last time order is being modified. The earlier order dated 39/2015 and absorbed the respondent 9 to 12 as UPO against the direct recruit quota retrospectively with effect from their respective date of joining on deputation as UPO, thus violating the recommendation of DPC dated 17/6/2015. Thereafter, on 16/9/2016, this is also impugned. Enclosure K. The impugned final seniority list of UPO was issued by the Secretary, Department of Urban Development and Housing, wherein all the private respondents 3 to 14 were shown senior to the petitioners. So this final seniority list is under challenge. Then recruitment of UPO is governed by Urban Program Officer Recruitment Rules 2006. That is enclosure L. UPO is a Group B selection post where appointment is made purely on the basis of merit. 50% of the posts of UPO are filled by promotion from amongst AUPO having 8 years of regular service in the grade for diploma holders
Mr.
and 5 years of regular
Just
service.
one clarification. This 9 to 12
Yes.
who have now been absorbed against direct recruitment quota from as UPO, they were brought as a UPO. This
I'm clarifying.
Tadartarang to Nabam Kai, page 13.
Just a minute. I have got a separate folder from 9 to 12. I'll be very specific. 9 to 12. 9 to 12, in fact, Lord, their cases are also very interesting. Each of them belong to very, very peculiar category.
No.
They were, my lord, I'm making it. They were junior engineer.
Be that
9
as
to
it-
12 were junior engineer PWD extension officer. They were brought on deputation
as a UPO.
to the post of UPO.
No, if you come to page 13. If you come to page 13 of your note,
Internal.
the following officers who were brought from PW to the department on encadrement basis.
My lord, yes.
Following were on deputation, so following 4 UPs were on okay, they were on deputation.
Yes,
UP.
that is why.
Fine. Please continue.
So 9 to, I'm just, since the lordship asked about 9 to 12.
They were brought on
Junior
deputation.
engineer in the PWD, they were there, brought on deputation
Mm.
to UPO under direct route quota.
Mm.
Though, my lord, under the rules, the deputation is can't be under direct route
It
quota.
has to be under the promoting. Okay, fine. So serial number 12, that is the list.
So,
which
my lord, all
finally
the
led
impugned
to-
orders, so impugned orders are enclosure F, G, J, and K. There are 4 impugned
F,
orders, yes.
F.
G, J, and K. Respectively, below the cross I will, because in the enclosures itself, the ratios are mentioned
I got it.
in the red. So practically the 5 issues, broadly speaking, my lord, when DPC recommended the promotion of respondent 3 to 14 with effect from 17/6/2015, and the same was implemented by the state by order dated 39/2015, making these respondents junior to the petitioners in the cadre of UPO, whether an administrative order issued without hearing the petitioners could unilaterally change the effective dates of promotion of these respondents, making them senior to the petitioners. Whether retrospective regularization or promotion of respondent 3 to 14 by an administrative order, contrary to the recommendation of DPC, would not amount to promotion, deholds the rules, and as such ab initio void. Because DPC is under the 2006 rules. Whether period of officiating promotion of respondent 3 to 9 as UPO, which was retrospectively regularized, contrary to the recommendation of the DPC, in defiance of the recruitment rules, can be computed towards their seniority in the grade of UPO. Whether respondent 9 to 12, who were appointed as UPO on deputation against direct recruit quota post, could be absorbed against such direct recruit quota post, and their seniority counted even though under the UPO rules 2006, they belong to promoting category. 5, whether respondent 13 and 14, who were given officiating promotion as UPO by order dated 6/7/2012, and who were recommended for promotion as UPO with effect from 17/6/2015 by the DPC of the said date, could be promoted as UPO notionally from 1/11/2008 by an administrative order and given the benefit of seniority in the cadre of UPO from 1/11/2008, when on the said date, they had not even completed the required length of 8th year of qualifying service in the cadre of AUPO, requirement for diploma holders, because both of them are diploma holders at the relevant point of
To
time.
fulfill the eligibility.
To fulfill the eligibility for promotion to UPO in terms of the mandate of law laid down in the division bench judgment of this court. Because in the Himarete case, the 2006 rules were interpreted by the division bench. I happen to argue this case also, Himarete. So that I will place later on. So this is the broad spectrum of the case, broadly speaking, which
Well-
covers in fact all the private respondent. Now, if we enter a bit more in respect of the 3 categories of the private respondents, then I'll just give another folder. That shows the enormity. First will be 3 to 8, followed by 9 to 12, then 13 and 14. Now I deal with respondent 3 to 8. There are other additional grounds which are attracted. And that shows the enormity of illegality which was done to favor these respondents. Lordship may see this photo. 3 to 8.
These notes can be shared to us also because,
These are all part of the writ petitions.
sir, you have made it, can you try to share it if possible?
Lawyers should work hard.
No
No.
comments.
We have worked hard, but then
It will be
share
given, it will be given later on. You'll get it.
For the next
Extra
forum.
copies will be provided.
For the next forum.
professional propriety.
Nothing is off the record, all part of the record.
Thank you.
Now, respondent 3 to 8. Respondent 3 to 8 constitute a distinct group of promotee urban program officers. They were directly recruited to the feeder cadre of assistant urban program officers and were initially given officiating promotion to UPO against direct recruit quota post. So, my lord, they came to the feeder cadre as direct recruit, that is AUPO. and then given officiating promotion to UPO initially.
Mr. Tiwari, just to understand this, can you take me through the rules first? Just
Okay,
to go
yes.
through the rules.
The rules, my lord, will find that
Page.
the earlier folder I had given,
Hmm.
the whole case, this is in
28.
fact, yes. The rule is
Urban Program Officer
Yes.
Recruitment Rules 2000.
for the benefit of my friend, it is an annexure 4 to the writ petition.
Oh, he knows has everything on his fingertip.
No, my lord will see.
No. Urban.
Yes, the last, the internal page 29.
80
The-
posts.
Yes, the method of recruitment, my lord will find in the chart at page 29, the last portion,
Hmm.
the last column.
Hmm.
Method of recruitment, whether by direct recruitment or by deputation transfer,
Hmm.
such and such.
50%.
Then, my lord, then here, the last page.
Huh.
50% by promotion, failing which transfer on deputation, absorption
Except.
by promotion. So 50% by promotion. By promotion from amongst the assistant urban program officer of the department who have completed 8 years of regular service for diploma holder and 5 years of regular service for degree holders in the grade. The word in the grade was interpreted by division bench to indicate it has to be as AUPO. Not by, so that way, my lord, division bench made it clear you can't through the back door bring in the SI Ruplal principle and say some parallel post, a junior engineer or something which is equivalent to AUPO. Your service as junior engineer will be counted so far as AUPO is concerned. That was discounted. The High Court interpreted no, in the grade, in the context, it would mean AUPO only. Provided that irrespective of seniority in the cadre of assistant urban program officer, promotion to the post of urban program officer shall be considered in order of seniority of completion of respective qualified service, failing which by transfer on deputation, absorption from central state such and such, So, my lord, deputation, transfer, officiation, whatever, it's all, my lord, part of the promotion quota.
Now, here there are two words given. Deputation oblique absorption,
Yes.
right? But in column 12, they have specified deputation shall ordinarily not exceed 3 years. Now, if there has to be an absorption, how will it be in this situation?
My lord,
Through DPC?
absorption has to be through DPC. That is the,
Fully
there's no other way. Power of absorption, my lord, ipso facto is not there in the rule. But in a given situation, we understand by relaxing the rule, one can also be absorbed. But the moot question would be, you know, because we are basically concerned by the fact, we are not worried as to whether they should be UPO or not. Let them be UPO, but they should be below us. So long as they are below us, we are not worried as to how they are made UPO, whether they are promoted against DR quota, against promotee quota is not our concern. Entire emphasis is let them be below us. They cannot supersede us.
That is the SI Ruplal case. where he has-
Sir, your chance will come.
Yes.
Your chance will come. Please wait for a turn. So, my lord, I just turned to respondent 328. My lord has seen the rules.
And you mean to say that the words in the grade,
That's the judgment, division bench judgment of the High Court.
Himatai,
Hemarete. Hemara.
Himarate.
But
It is reported also in GLT and GLR. I have given the citation.
Okay.
Just since your lordship is keen to have a look at it. Yes.
Yes.
My lord will see para 13 to 19. This is summary.
Sir, citation तो बता दीजिए.
Citation is बताओ.
2017-3 GLR 409 or 2017-3 GLT 353. Para
13 to
Sir, three. मतलब three.
2017-3 GLT 353
or 2017
3 GLR 40.
409. GLR, it is para 13 to para 19.
The division bench.
Yes, division. But I think the paragraph would remain the same. I hope, my lord, there,
Fine.
para 13 starts from in order to appreciate the contention. With the, my lord,
Ah,
start, yes,
that's correct.
correct. The paragraphs are same, that is why. Paras are same. In order to appreciate the contention advanced by the appellant on the aforesaid issue, a reference is deemed necessary to the relevant provision of the draft rule such and such, such and such.
It becomes apparent that the experience clause
Clause 12 indicates the method.
relate to tenure. in
Para
service.
14 what should we see?
Those per experience in the parent department would have not have any bearing. Computing suspensions and so on. Their reading of the set clause would not be entitled to any credit of past service for computing inter-se seniority. If that be so, we fail to understand the true purport and so on, so on, so. Be that as it may, promotion being appreciated. So and so, the president is representing a graduate degree holder, so and so on, will be required to conduct by-
The analysis of the rule is in para 18,
18, I've seen it.
18 and 19. A bare reading of the said clause would go to show that a candidate would not be entitled to any credit of past service experience for computing the inter-se seniority in the rank of a UPO.
This deputation
If that
is
be so.
our respondents number?
Below, they are 3 to 8.
No,
No,
from 10 to
For
Yes, yes, yes.
deputations.
Deputationist,
Hmm.
yes. They are,
10 to 10, 11, 12, 10 to 49.
um, yes. 13 and 14, my lord, and there are two categories in fact of deputationist. The deputationist are
10,
9 to 12, please,
No,
please.
the
sir.
deputation is who came directly as UPO.
So far as respondent 9 to 12 are concerned, they were brought on deputation to UPO directly.
Okay.
So 9 to 12, deputation to UPO directly. Then 13 and 14, they were, my lord,
AUPO, then promoted as UPO.
they were junior engineer
Ah.
in PWD, transferred on deputation along with 8 others as AUPO to Department of Urban Program Office. So
And
junior engineer sent on deputation as AUPO.
And then they were promoted
Yes.
as UPO on officiating basis, and
Yes.
then that was.
Yes, regularized.
Mr. Sonar, you are appearing for?
My lord, I'm appearing for my lord. Respondent number 10, 11 and 12, my lord.
10, 11 and 12. That means the direct,
lord.
deputationist,
From deputies, from the PWD department.
directly. And Mr. Tarak,
And 13 and 14, you know. Transfer.
you mean you were AUPO, absorbed, then promoted, officiating, then regularized. And Mr. Tapak, you are for? Four. Four is Punning's clients. In the other
No,
case.
that is other case.
No, 4, item number 3, brother.
Item 3.
Wait,
Sankol-
Four is, what is it, four? Okay,
In item 3, you know, item 6 and 7.
no, I only want this item number 2. Got it. So, Mr. Tiwari, if I've understood this matters preliminarily, your basic projection is that you all have come in, no problem. But there is a rule, and the rule mandates a particular process. Now, you people were subjected to that process.
Yes.
On being subjected to that process, a outcome came out. And the department accepted that outcome and implemented it.
Yes,
Now, if there is something to be done, that outcome, basing on which the consequential actions have been taken, have to be reviewed by that same body. Without that body going into that preliminarily, without that body reviewing that, these actions are null and void.
You know, there's another way I'll put it. Because the moment we concede even this much,
They will do it.
they will do it that way. The question is whether DPC also could have done it. Because then we have to look into their facts. The facts are such. The way they are born, the very genesis of their birth, and their development, they evolved, the manner in which they evolved as UPO. It is so incurably vitiated that even DPC could not have validated.
Means your endeavor is to try that this court, if it comes in your favor, leaves no opportunity for them to come back.
Yes, to come back above us. Above us.
Come back to this forum again. They can go to appeal, that we can't.
They can always file petitions before any forum, nobody can
No,
stop
no,
them.
I'm not on that.
But the state should not be able to
Review.
use any such device by which again they are brought above us.
It's good. That I like you to, people come for
They
the.
have conceding now 8 years, 8 years. This case could not be done.
You are here for the day,
Oh, yes, I am here for that.
not going back today.
I would like to, but then I'll complete the case. Otherwise, my lord, this case would never see the light of the day.
Well, after 3:30, I will not be here in this court.
Or my lord, next week we can continue. Tuesday, I'm again coming. There are cases.
Usually you start.
Next week, my lord, I won't be available, my lord.
I can't have this matter on online basis, my lord. I'll have to, because next week till now, my program is till Friday. I'll not be here on Friday till Thursday.
My lord.
Friday, there
That's
might
why,
be
my
some
lord,
difficulty.
last time we consented for today. Last week, next week, my lord.
Mr. Sekia is not here. Mr. Sekia
No. I don't want to detain him if the matter is not over today. Why should I detain him? When are you coming?
I'll again, next week, I'll be here from Tuesday
Mr.
onwards.
Sonar, you make your submissions today. Mr. This is basically your projection. We'll go into the integrities, don't worry. You take down notes, Mr. Sonar, you complete your part. We'll have it on Tuesday. If possible, if something is required, we will have it on Wednesday or Thursday for your comments. You come online.
Or written argument they can give.
Mr. Sonar, where will you be?
My lord, I'm out of station, my lord.
Out of station.
My lord.
You come in plain dress online. I'm permitting you.
My lord.
Tuesday.
Just nutshell. I would be the happiest person on the earth if Tiwari sir's client go happily home from the day they were born to the cadre, not from 2005. That is the
2005? I don't know what commission is. I have not understood. That's
Mr.
not my
Tiwari,
case.
law is settled.
agreement?
That's
On Tuesday, we will close this.
Correct.
And Mr. Suna, you come online. Wear civil dress, no problem.
Where
My lord, Tuesday at some different matter, my lord, outside.
Finish that and come. You'll be on dress. Come online. Hey, link there, then.
My lord, I'll be out of the station, taking all the things. I'll be going for some
Mr.
other cases,
Sonar,
my lord.
Others may not know you. I know you from the day you were born in the profession.
My lord.
I know how you can pick up things. So do it.
My lord.
We don't want to finish. We have
Right.
got the hang of the matter, only I want your thing.
Well, actually, the government has to,
We'll hear the government at last.
no, they are the ones who are supposed to justify their actions. Then we can supplement.
No, no,
Mr.
I'll,
Sonar and Mr. Tara can
Mr.
supplement.
Tara, I want your expertise here. I want your view. Thereafter, we will go to the government,
That's great.
right? I'll not trouble him now.
No,
Tuesday.
I'm reiterating.
Colleague, heard in, Mr. Tiwari, P.K. Tiwari, counsel for the, counsel, counsel appearing for the petitioner. Hearing remains inconclusive. List the matter again on Tuesday. The counsel for the private respondents have also submitted that they will also complete their arguments on the next day. The learned counsel for the respondents are also permitted to bring on record their arguments by way of in a written form, along with the judgments they wish to rely upon. Such written arguments be filed at least a day prior to the next date of listing. List this matter again Tuesday.
Sir, Tiwari sir may kindly be requested to share the copy.
Mr. Tiwari will go away now. you catch hold of Mr. Saxena.
Tiwari sir is not kind.
Please,
this time.
kindly.
I don't know why.
Just a
Very
minute,
unprofessional this time.
may I, so far as other private respondents are concerned, there are separate write-ups.
You give me
So
that.
that also I'll give.
You give it to me,
Uh,
I'll upright mine. But basically, Mr. Tiwari, this is the gamut.
This is.
You can just give it to me.
Not only one thing, the registry is very conservative so far as English language is concerned. They keep on looking for the word hard in part. So if that word is missing, they have their own wonderful interpretation of
Hard in
language.
part. Excuse,
Because it has happened in Guwahati also.
but not with me till now.
Very well.
Not with me till now.
I know. So 3 and 8, Lordship has not got it.
I have got 3 to 8, relevant facts pertaining to 3 to 8.
9 to, okay. Then 13 and 14. I'm giving 9 to 12. 13 and 14 and 9 to 12.
You give him them also a copy.
I'll provide. I have
Soft
brought
copies,
soft copies. All right, that Mr. Saxena will do that.
soft copies.
Not hard copies.
They are very tech savvy.
I know.
They don't like this.
Especially Mr. Tara.
Not Tara is, he doesn't like hard copies.
There is special bonus.
My lord, this is a joint application, my lord, by the informant as well as the accused person, my lord. My lord,
There is
both
a
of them
compromise degree.
compromised, my lord, at page 28, my lord. Sorry, 38, my lord, 38. In fact, my lord, both of them, they were working in the IRB, my lord.
Of same department.
Yes, yes, my lord. On that unfaithful day, my lord, the one was in duty, the other was not in duty, my lord. And due to a misunderstanding, my lord, when the informant he was in duty, they had a misunderstanding in the quarrel between each other, my lord. They were not known to each other at that point of time, my lord. After that, they came to know that they were from the same department, they compromised.
Yes, Mr. Eric, what do you say?
Yes, Your Lordship, since they compromise and as per the agreement, the compromise settlement, it has been entered long time back in 2011 itself. Your Lordship. And the offense, both the offense is punishable maximum up to 3 years. Your Lordship.
Please. And with this, he will not now go and even support
Yes.
his FIR.
Yes, sir.
Close it,
Yes, sir.
dispose of. I'll pass the orders.
Obliged,
You'll get the orders day after.
my lord.
Obliged.
Dispose of. Then adjournment. Then adjournment. 10 was adjourned. 9, 10, help make a name adjournment. No need to pass it, it's already adjourned.
May I please,
आदमी जो बेचा रहता है कौन change और नहीं आगे बेचा रहता है सिविलियन बेचा है कौन सही में एक एजेड आदमी बैठा है कौन डेली देखता है क्लाइंट देखता है एक बार पूछे तो क्या
LCR was called for and it has been received, Your Lordship.
What is it?
302 case, Your Lordship. Trial,
Charge sheet
Your-
filed on?
charge sheet,
filed, yes, sir.
Here, what is the stage of the proceeding?
or perhaps on appearance is still.
No, my lord, the investigation team, they are waiting for this FSL report. Therefore, CC could not be played. My lord, this application was filed on 14 May 2024. During the filing of this application, my lord, there was no supplementary charge sheet. I don't know how, after 14th of this month, my lord, if the I of the case has filed the supplementary charge sheet or not. That's lordship, I do not have any idea. But on 14, when this application was filed, it was the supplementary, yes. Now lordship, the case was listed.
This is a part charge sheet or final charge sheet?
Perhaps, Your Lordship, supplementary charge sheet has been perhaps filed, Your Lordship.
So with regard to the latest Supreme Court decision, they will be entitled.
Your Lordship, the question here is, the allegation is regarding the heinous offense here, 302. And Your Lordship is well aware that the condition laid down under section 437, subsection 1, clause 1 is a sine qua non for granting bail even under section 439, Your Lordship. And section 437, subsection 1 provide that the accused is not entitled for bail if there is a reasonable ground to believe that he is guilty of an offense which is imprisonment for life or death, Your Lordship. So that has to be overcome by the accused, Your Lordship. And it has been held by the Honorable Supreme Court that in this kind of cases, Your Lordship, the period of incarceration cannot be a ground for even
No,
granting
that,
bail.
that.
And so far as material is concerned, Your Lordship, the materials are there inculpating the involvement of the accused, Your Lordship.
He is the one responsible for the death of his wife.
Yes, Your Lordship.
My lord, that is the prosecution story, my lord.
That much only we have. You have your opportunity when the
My lord, the petitioner has filed one additional affidavit.
where?
It was filed on
It's here.
saying that, my lord, the son of the,
Where
Accused.
is the son, minor son now, after the death of your wife?
my lord, I have first and second wife. The victim, this is my second wife.
Second wife.
Yes,
2020 you married.
yes. And the marriage is in fact going to solemnize on December of this year. But before that, this incident has happened. In fact, my lord, the accused,
Mr. Eddie has produced, petition PP has produced the,
Your Lordship, it was routed through registry, Your Lordship, LCR.
okay. The
PCR,
LCR,
PCR.
The LCR. Scan copy of the LCR has been received. And the same is attached with the records of the case. Also, list this matter again on Friday. Let me go through it once.
Yes, sir.
Satisfied.
Deeply obliged.
कुछ दे देना।
right there.
या वो तो आ ही जाएगा, कल आज तो आ ही जाएगा।
Your Lordship, item number 13, charge sheet has been filed and it's been charge sheeted under section 323, 341, 34. All the sections are available. So therefore, Your Lordship, this application is now in infructuous.
My lord, may close it by the recording by Learned Francis.
Mr. You are what at a G T learned additional PP appearing for the state respondents has submitted at the that in the present case the charge sheet has been filed by the investigating authority on
14/5/24.
14/5/24
24.
under sections
Under section 341,
341,
323,
323,
34,
and 34 of
IPC.
the IPC. Also, it is submitted in the past that the said sections being bailable sections,
Yes, sir.
the apprehension of the petitioner as raised in the present proceeding of arrest does not exist anymore. Also, in view of the said statement of the learned additional PP, Mr. D. Pani, learned counsel appearing for the petitioner submits that the court may close the present AB by taking note of the submissions as made in the matter by the learned APP. So accordingly, in view of the said statement and the filing of the charge sheet under bailable sections, there is no further need for any adjudication in the present AB and the same stands closed.
14 also same order.
13, 14, same.
Same.
Yeah, and Your Lordship, charge sheet number is 1 of 24. Charge sheet number.
Charge sheet number, हम दुका देगा मार दीजिए. Charge sheet number 1 of 24 dated 14/5
2024.
13, 14 में same order होगा. दो order मार दीजिए.
Deeply obliged.
Who is appearing for the petitioner?
They are not present, you see, in the court.
Same, the none appears for the petitioner. seen the office note dated 21/5/2024? Steps for effecting dusty service upon the respondent number 6 is found to have not been taken. So the petitioner is granted 10 days time to take the requisite steps in compliance with the order dated 25/4/2024 passed by this court in the present proceedings. Full stop. No interim orders.
Obliged.
Have you filed an application for substitution? No. Of respondent number 1?
Lordship,
Respondent number 1 substitution? Because the office note reflects that he is no longer in this world.
to that effect, I'll file. Step is already taken, but
No, he is no longer addressee deceased, return to the center. So you'll have to bring on record. Now you know about it.
I'll file application to that effect.
The office note dated 24/4/2024 reflects that the service of notice upon respondent number 1 was not effected in view of the fact that the respondent number 1 had since deceased. Also, further, the office note dated 21/5/2024 reveals that the steps service of notice upon respondent number 2 is not complete. Also, petitioner to take fresh steps for service of notice upon respondent number 2 and to take appropriate steps in respect of respondent number 1 for substitution of respondent number 1. List this matter after 4 weeks on a date to be fixed by the registrar.
Lordship,
2 things. 1, respondent number 1 is not there. Confirm that. If he is not there, substitute him. 2, the respondent number 2 service was taken in March. It has not yet completed. Take fresh steps.
Lordship, otherwise also, as per previous record also of this honorable court, he says that the service is completed actually.
But the office
Yes,
note is
previous record says.
service report in respect of respondent number 2 is still awaited.
I think-
24/4/24 unserved notice returned back to this registry in respect of respondent number 1. Indicate with postal note addressee deceased. Return to the center and the same is kept with the record in part 2 file and service is awaiting for respondent number 2. This is my registrar's note. How can I go beyond that?
sometime in the month of January or somewhere.
January?
Yeah. Both respondent 1 and 2, they have acknowledged.
(26/9/23) fresh steps. Directed. Right? Earlier, there was a order wherein it said the appellant has given the copies. But again, 26/9/2023, there is an order. D. Bose,
Yes, I am.
your learned counsel shall once again take steps for service of notice upon respondent number 1 and 2. Then on the next day, you did not appear. Thereafter, on 22, you prayed for 3 more days time to comply with the directions. And then again, 25/4, you did not appear. And today the matter is listed. So we have passed that order. So kindly take appropriate steps.
Oh, obliged, Lordship.
My lord, I'm appearing on behalf of counsel for the petitioner, M.K. Singh.
Seen the office note dated 25/2024. The service upon respondent number 2 is stated to be not complete. When was the steps taken here?
In the month of November last year.
The petitioner is directed to take fresh steps for service of notice upon the respondent number 2 at the correct address of the said respondent. Right?
Yes.
Steps within 3 working days. So list this matter again after 4 weeks on a date to be fixed by the district. इन लोग का नाम लिख दीजिएगा record stage.
Deeply obliged.
Yes, Mr. Devi.
Yes, my lord, this is a quashing petition, my lord, quashing of the criminal proceeding pending before the learned judicial magistrate first class. Well, kind of charge sheet, my lord, this operation portion. There is a retired person, my lord, at the age of 80 now. Allegation is that I have used a false document in participating in tender process. This is the allegation. After
Steps are
knowing,
complete. Steps
Yeah,
are complete. Who is
steps
the
are
appeal
complete.
of respondent number 2?
Yes, I appeal.
my lord, relevant paragraph, my lord, paragraph number 12, page 26.
No, we'll have it for admissions.
My lord, because he is a old age person, my
Fine,
lord,
we'll have it immediately.
80 years.
No problem.
And this section is also not applicable because I have not used.
That
Moment,
document.
moment I came to know that I have withdrawn from the deed.
The Mr. So and so, your name?
Ketan.
Okay? Davi. Learned Counsel has entered appearance for the respondent number 2, while Mr. Opada represents the respondent number 1. Also, service upon the respondents are complete. Mr. S.K. Devi, Learned Counsel for the petitioner is present. Full stop. Accordingly, list this matter again on
Well, Tuesday, your lord.
Tuesday. We have that Mr. Tiwari's matter. It will take a long.
Then Monday, your lord. Because
You are here on Monday?
I'll be here.
Monday, 27.
Because he is a old age person.
Fine, we'll consider. 27. Mr. Parab, you be ready with your submissions.
Obliged. sir.
IA is for condonation of delay of
Huh?
this, IA is for condonation of delay
Hmm.
of 681 days in filing the appeal against the judgment and conviction order dated 30/12/2021.
None has appeared for the respondent number 2. Victim? Nobody has appeared for the victim.
Nobody, Malab, notice has been already served.
We'll give them one more date, and on the next date, we will condone the deed. List this matter. It is seen that the service of notice upon the respondent number 2, that is the victim, is complete. However, none has entered appearance for the respondent number 2. So there is no one representing, no, forget it. So in view of the matter, a further chance is provided to the respondent number 2 to place objections, if any, with regard to the application for condonation of delay. Full stop. Accordingly, list this matter again on 29. Will you be comfortable? You're comfortable? 29 side. You are paying for?
I'm appearing on behalf of the applicant in the IA, Your Honor.
Hmm.
And this IA should have been named as Kaling Borang versus Alok Time. However, it has been reflected as Alok Time. IA, the applicant is Kaling Borang.
I think you have corrected it. ISC 87 AP.
In the cause list, it's been reflected as Alok Time.
No, it's been corrected in my copy.
None of this
Alok Talang
IA
is the
respondent.
the petitioner in that.
He is a
CRP.
petitioner in CRP. This IA has been filed for
You are for the
impeachment
petitioner.
of.
Madam, I am for the respondent in the item number 25.
Okay. Who is for the petitioner in item number 25 and the respondent here? You are for the petitioner. She has submitted this application for impleading. We have any objection? If you have an objection, you can file an objection application, no problem. If no, tell me, I'll implead. How long have you been practicing?
Only 11 months.
11 months. And why are you keeping things to yourself? When you come to the court, open up. Don't keep it to yourself. Court is not here. Court is here to hear you. Got it? Need not be afraid. If you are afraid, if you can't say, you will never be successful. Be bold. Leave all your fears in that door outside. You come into the court with fire. You must make me listen. My habit is bad. I'll ask questions. But you must make me listen. When? Friday? Monday? Monday. We give him a chance. On the prayer of Mr. Huh? B. Shiv Learned Counsel appearing for the respondent, opposite party in the opposite party. IMA Mariega. Opposite party prays that the matter be taken up on 27/5/2024. If you have objections, tell me on that day. Read. If not, we will implead it.
Deeply obliged.
And next time, this space will not do. Yes, Mr. Pani.
Yes, sir.
Before Mr. Pangini starts, Lordship, this is a case of case. So Neris has decided, or they are going to convene the board meeting in next month. So that is in agenda, this matter. So I pray that this matter will be taken up after 1 month.
Mr. Bharat,
Upon
I remember last time when I was here,
Lordship.
the same prayer
Yes,
was made
yes, yes.
that you are trying to.
Today I am in written, Lordship.
After page 74, my lord, there is no question.
No, that case with regard to fixation of pay
Yes.
and all.
Yes, yes.
I think we heard this at details once,
No, it was not
Some-
exactly
no,
heard.
no.
but we had some deliberation.
Yes, yes. After
There were some earlier decisions which were not being followed, they
Yes.
changed it, which
Yes.
you had a grievance.
Yes.
Yes.
The
Now,
person is some,
after page 74, my lord, there is no question, my lord.
'74,
4. Annexure J,
mixture of your writ petition.
yes.
Yes, what is that letter you have?
Lordship. Thank you.
Page 80 is the relevant portion.
Earlier orders of this.
Yes, yes. how it was closed, my lord, second para onwards. If not in dispute, that if the decision is reflected in the order dated 12/1/2016 is implemented in case of writ petitioners, their grievance expressed, the writ petition will stand addressed. However, the appraisal of learned senior counsel for the petitioner is that the notification does not lay down any definite time frame for implementation of the scheme. As such, the learned senior counsel prays for appropriate direction from this court fixing a time frame in the matter. In view of the above, and taking note of the submission of the learned senior counsel appearing for the parties, I am the considered opinion that nothing survives for adjudication and writ petition. That is because they said that they are going to do it. It is, however, made clear that the decision reflected in the order dated 12/1/2016 would be implemented in case of the writ petitioners as early as possible, preferably within 3 months. This has not been put to challenge, my lord. This is attained finality. That 12/1/2016 order is at page 73.
What is this 10/1/2017 order?
10/1, my lord.
That contempt case was closed on the basis of that.
Yes, that is because they say that thereafter again they said they are going to do it.
But
That
they
is-
did it in a
Yes,
different manner.
Yes.
Where is that order on the basis of which this was closed?
There is a page 73. It was implemented earlier. They kept it in abeyance. We filed with petition. They issued this order. Is kindly accorded approval for re-implementation of the office order dated 9 May such and such regarding upgradation of faculty members of undersized CAS from the eligible date on individual basis and sanction such and such. This was placed. That is how the order in the petition can be passed. How can now?
Sabang, once you have undertaken before this court to implement this page 73, how can you go beyond that?
Lordship, if my prayer is not considered, Lordship, then I
No,
move
no,
to.
we don't want,
No,
we don't want
Lordship.
in every matter the court should go and close it.
Lordship, that's well, Lordship.
You are an employer, it's your duty to see that your employees' welfare is looked into.
Yes.
But my only grievance question is, once you have undertaken to decide the issue
Lordship.
in the manner as was agreed and recorded in the earlier order,
Lordship,
this order,
if given chance, Lordship, I'll satisfy the honorable court because the members who are going to decide are not only from Neris,
we are least bothered.
Lordship.
We are least
Now-
bothered. We are bothered. We know that there was a decision, X, Y, Z, whatever it is. You required this court to close the matter on the basis of that, saying that we will do it. Their
Yes.
only apprehension was that that scheme, that order
Time
on page
frame.
73 did not have a time frame. So they said, fix a time frame. We have fixed the time frame.
Lordship, that's why,
And,
They-
and anyway, you approach this court by way of, they approached by way of a contempt. And that contempt was closed basically on an order of 10/1/2017,
The
which
registered
they are
agent-
not satisfied. They say it's in violation of the agreed procedure. That's the procedure.
Yes.
How can it be? We'll ignore that contempt.
Lordship, that's why,
We will proceed against your officer.
Lordship.
Who's the man? Register. No, this is,
They-
Mr.
Lord-
Apang, they cannot take you for a ride. They are trying to take you for a ride.
Lordship,
Through you, this court.
Lordship, if that's the view of the honorable court, let the matter be fixed on Monday or Tuesday. I'll satisfy honorable courts.
I want an order of compliance, or I'll have your officers here. This is not done.
Lordship, Monday, I'll try to satisfy on this honorable
I
court.
don't want
also.
satisfaction. I want the compliance. You go before the court, wherever you want to go. But this order stands. We are not satisfied with this 10/1.
That's
If it
well,
is in violation, it is in violation.
that's well, Lordship. Let the matter be taken up on Monday. I'll try to satisfy honorable court.
I want an order. I want an order of compliance. How old is your petitioner? Retired?
Yes, some of them
Sir.
retired.
Why are they being troubled?
Not only them, Lordship, others are also,
We are
round about 70 of them are there, all the employees.
62 in 66. No. His right crystallized with this order. And why did you permit the contempt to be closed in that manner?
My lord, I can't say anything about the at this point in time.
We'll ignore that contempt closure. I'm sorry.
Lordship, let the matter be taken up on Monday, Lordship. It's my
No,
prayer.
Mr. Apang, we have nothing against you. You are acting on the directions of your client. What can you do? I know, Mr. Apang, if it is to Apang, he will say, my lord, direct, I'm using it. But you can't do it anyway. If it was a private client, it would have been a different issue.
Yes, that is there,
But
Lordship.
this is an
That
organization, but
that is there.
I want Mr. Apang to communicate this to the authorities.
Lordship,
We are not going to follow this.
Lordship,
You can't have a relook into the matter once you have said, see, apprehension of the learned seniors. Mr. Apang says that may be disposed of with the direction that the aforementioned decision will also be implemented in case of the petitioners here. That's the end of the matter. We don't know what the decision is. Whatever it is to the advantage, disadvantage of the employee, he has accepted that. But you must give it to him.
Lordship, I'll try my best to.
We'll have it on Tuesday. If not,
Lordship,
on Wednesday, I'm calling all your officers.
Lordship,
I'll draw up suo motu contempt
Lordship.
on the prayer of Mr. A. Apang, Learned Senior Counsel, assisted by
Keep in
Keep that name. This matter stands adjourned to
Can it be Monday, Monday, Tuesday, London Senior Council matters?
on Monday. Monday. What's up? Mr. Junior Counsel, so and so assisting Mr. A. Apang shall receive instructions from the authorities as to why this court would not pass orders drawing suo motu contempt proceedings for the violation of the undertaking given before this court and recorded in the order dated 27/4/2016 passed in WPC number 91 AP 2014. So, in the event, on the next day, the said instruction is not forthcoming and or submitted to the council assisting Mr. A. Apang. Full stop, Mr. Apang, full stop. Further orders as may be called for in the matter shall be so passed.
Lordship, then can it be on Wednesday? Because I have to communicate the instruction also.
Tuesday, because I want 1 day.
Yes.
If I have to proceed against them, I'll have to have 1 day.
Lordship,
Mr. Apang, use your office.
Lordship.
Next day, we want this settled. This is not. This reflects on the court.
Yes.
This reflects on this court, and you are a part of this court. Once we have passed an order, you go up on appeal, you go to the Supreme Court, we have no problem. But that standing, you can't have a conflict. At least this court's view is that.
Lordship, I'll try my best.
It's only 6 months that I have crossed over. So that endeavor is always there.
Lordship,
So we'll have it on Wednesday, and I hope you will not allow Mr. Panning to even say a word. That the matter is disposed of, closed.
Lordship,
You can. You can. It should be done.
but
We will, maybe I'll pass an order. You go up on appeal,
Lordship,
wherever you go. But this is, at least in this court, I'll not permit.
Lordship,
And Mr. Apang knows it. And you use your good office. Thereafter, if they don't come across, we will see what can be done. Right?
at least Lordship, I'll come why and why not. That
I
we
don't
can
want that
understand.
why not. I want the why not. This undertaking was, let them come up and say that they had not given you this permission. They have not said that till now, have they? That Mr. Apang had made the undertaking without our consent. Have they said so?
No, my lord, the order was
then-
placed before this honorable court.
Then
It was on a written order.
written order. Then you find out that written order.
Yes, page 73, my lord.
No. That this order would be applied to the petitioners. It's written there.
No, my lord, they have said that they are going to,
No, that portion of the order.
say, page 7, my lord, kindly have page 73. So what the honorable court has said, that this should be implemented, 12 January 2016.
It's a reasonable order.
Yes.
Okay,
Lordship,
Tuesday.
Tuesday.
Let's see what they give to the council, junior council to Mr. Apang, instructions.
Order is clear enough, my lord, today.
Mr. Apang knows it. But if it was a private client, he would have said, I'll do it. It's a government client. He
Yes,
can't.
I understand.
He can't. Anyway, let's see what can be done.
Okay.